What we'd like to do now is to give each of our speakers a minute to maybe 90 seconds, should they choose to use it, to give us some key takeaways, basically a summation of what they feel are the key points they want the audience to come away with. So we're going to do it in the order that the speakers appeared. So we're going to start with Dean Finelli. Dean, some key takeaways, please.
Thanks, Sal. Yes, so, my segment talked about some of the background and not the substantive litigation. So on the background, I think some of the key proposals were, as Tim just mentioned, there are 9 biosimilars that have FDA approval. Only 3 are marketed. That's likely that the other 6 are not marketed due to litigation concerns. The biosimilar industry, it's a very there are a lot of patents, a lot more patents involved in bringing that are around a biotech or a branded biosimilar type drug, as opposed to a generic where typically you'll have a handful, maybe in some cases 10 listed in the Orange Book. So I think the most important thing I'd say is, start doing the diligence and doing the analysis and all the pre-litigation work well in advance to make sure that you identify the patents. There's not a neat place similar to the Orange Book for small drugs that biosimilar applicants can look to find a concise list of patents that are relevant. They oftentimes have to go out, do an exhaustive FTO search. Typically, on the small molecule side, we have seen that the most relevant drugs are to the compound, whereas on the biosimilar side, a lot of these process patents that are out there are just as important, if not more important, than the underlying patent to the actual substance, due to the fact that a lot of these processes are very, very specific and they're not easily able to design around these patents. So generally, I'd say do everything very far in advance. Get your in-house counsel and outside counsel involved and to identify those patents, in order to make an appropriate decision whether you want to do the dance, whether that's appropriate for you, the number of patents, when your exclusivity is going to expire. There's a lot of issues out there that have to be answered. So your take-home point is do your diligence well in advance.
Thank you, Dean Finelli. Jamaica Zeliga, some key takeaways, please.
Thank you. So I think that the key takeaways that I want to leave everyone with is when it comes to the patent dance and whether to dance or not, that is a very complicated choice. It involves a lot of factors, a lot of decision making, and it's a situation-by-situation evaluation that has to occur. The main benefit of the patent dance is you control the number of patents in that first phase of litigation. That can be a critical tool. The main disadvantage is you are disclosing a lot of information during the patent dance process. Second main point is to be on the lookout for what gets included in the ABLA and also what you put in your patent dance disclosures. It's now clear that the documents that both sides exchange during the patent dance are going to come back up in litigation. And if you said that your concentration was 1 gram and it turned out that you were wrong and it's actually only 0.5 grams, then the other side's going to look at that 1 gram and they're going to say you admitted 1 gram. And you're going to have to prove that no, you were just wrong. You might as well avoid that issue at the beginning by being very careful about what you disclose. Final point is just things are still unfolding. This is a very active area of litigation. We expect a lot of questions to come out. We have not gotten to phase 2 litigation yet, which could bring about a whole other set of complications. So definitely feel free to rely on any of us for an update on this area. We try to stay on top of everything.
Thank you, Jamaica Zeliga. And finally, Tim Shea, take a minute for some key takeaways, please.
Yes, I think what really in looking through the cases that are pending in terms of the district court actions, what we see from the Sandoz case, the Coherus case, the Hospira case too. We're seeing again just how important these process patents are, as we had identified early on with the BPCIA, just the sheer pool of potential patents that can be asserted in a biosimilar litigation as opposed to a Hatch-Waxman litigation. It's just much larger, and the process patents are central. We're seeing that these cases, a lot of these cases are coming down to process patents are the ones being disputed. We know that of the 72 that AbbVie has identified, for Humira, a lot of those are process patents. Genentech in both the Avastin cases with Amgen and in the Sandoz case, there's a lot of patents. At least half the patents that are of the 24 that are or 30 that are being asserted are process patents. So it really illustrates just how important the process is to biological molecules. It illustrates the importance of these patents to this type of litigation. And to be honest, some of these patents a lot of these are extremely, complex, and turn on very fine technical points. These really have to be something, I think, that are carefully analyzed and vetted well in advance of the filing of any ABLA, as best can be done, because what we're seeing is it's just a huge component of biosimilar litigation that's not something we really saw to anywhere near the same degree in Hatch-Waxman litigation.